Everybody, how's it going? Welcome back to Copper Jacket TV. So today we're going to be talking about arguably the most important case currently sitting before the Supreme Court right now, which is Snope v. Brown. Snope v. Brown is a case that challenges Maryland's so-called assault weapons ban. Now, over the summer, we got a decision from the Fourth Circuit Court of Appeals in this case, who basically said that the state of Maryland is allowed to ban them because, well, they're too similar to what's being used in the military. Not long afterwards, however, a petition was filed for a writ of certiorari to the Supreme Court. Now, soon after that, Maryland started its games. They basically started stalling and delaying the Supreme Court, hopefully trying to push this case into the next era. But the Supreme Court wasn't playing games. Well, we've been waiting for an update in this case. We finally have one, and so I want to talk to you guys about that today. Now, real quick, if you're somebody who carries to defend yourself or your loved ones and you're doing so without an attorney in your back pocket, you are doing it the wrong way, because heaven forbid you're out there and one day you actually find the need to defend yourself and the details get a little bit fuzzy, you could be the one that ends up in handcuffs, in which case you will need somebody on your side, and that's where attorneys on retainer comes in. Now, with that attorneys on retainer membership, you do have an attorney in your back pocket, because if something, God forbid, happens, all you have to do is simply call the number on the back of that card and you will speak to an actual attorney who can guide you through the next steps. They will also get an attorney out there to defend you. You can choose one from their network or you can choose your own attorney. They are not an insurance company. These are attorneys that are working directly for you. So it is the same as having an attorney ready to go in your back pocket at all times. Now, like I said before, if you're somebody who carries to defend yourself or your loved ones, don't go it alone. Check out the link below to attorneys on retainer. I've got some discounts down there as well. But this is extremely important to your life, your livelihood, and your freedom. Okay, so let's go and talk about what's going on here. Now, you might know this case under a different name. It started off as Bianchi v. Frosch, then it became Bianchi v. Brown, and now Bianchi is no longer involved, so it's Snope v. Brown, but it's still the same case that's been going on for quite some time now. Now, this case is just an absolute mess because Maryland has tried their absolute best to delay it for as long as possible, but thankfully the Supreme Court put a stop to it. So back on August 23rd, that's when this case was originally petitioned to the Supreme Court. So that meant, since it was filed on August 23rd, the state of Maryland had 30 days to reply. That put a date of September 23rd for a response from Maryland, but Maryland said they needed an extension. They needed a little bit more time. So they asked for an extension of 30 days, putting it to October 23rd. The Supreme Court granted that. Now, that means that now we had to wait till October 23rd to get a response from Maryland and to see whether or not the Supreme Court would put it on their list for conference, and we would know whether or not the Supreme Court was going to take the case or not. Well, guess what? Not surprisingly, the state of Maryland asked for another extension. They said that they're just too bogged down in Second Amendment litigation. All their attorneys are spread so thin that there's no way they could possibly take somebody aside for this Supreme Court case. So they asked for it to be pushed out to November 22nd. Well, the Supreme Court said, we're going to give you a little bit, but that's it. That's enough. You get enough extensions. It's time for you to address this. And Maryland finally addressed it. But in doing so, it seems to me that Maryland basically hammered the nails into their own coffin. Now, what I mean by that is just based on their response, and we'll take a look at least part of that response here in just a minute, there is no way that Maryland is going to be able to successfully argue the merits of this case and uphold the Fourth Circuit's opinion if this actually gets taken by SCOTUS. Just take a look at what their argument actually is. Okay, so here's a quick look at the introduction to their brief in opposition. Now, they're sticking very firmly to their belief that so-called assault weapons don't even fall underneath the protection of the Second Amendment. As a matter of fact, they're not even implicated by the text of the Second Amendment because they're too similar to what's being used in the military. And I can tell you right now that that's just going to fall flat at the Supreme Court. But let's go ahead and take a look at what their argument is here in the introduction. So it says here, and I might paraphrase a little bit, in the District of Columbia v. Heller, this court left no doubt that, quote, weapons that are most useful in military service, M16 rifles and the like, may be banned. Well, I can tell you right now, the civilian version is not useful in military service, and I think that most people in the military can attest to that. Consistent with that pronouncement, the state of Maryland and 9 other states and the District of Columbia have prohibited possession of certain highly dangerous military-style quote-unquote assault weapons. Now, it continues on to say, and I'm just going to note that this is where it kind of gets disgusting and you could see the activism just spilling through here. But it says, this court's decision in the New York State Rifle and Pistol Association v. Bruin left intact its pronouncement in Heller that M16 rifles and the like, quote unquote, are weapons that, quote, may be banned, end quote. Nonetheless, this court vacated an earlier appellate decision in this case and remanded for consideration in light of Bruin. The en banc Fourth Circuit Court, in turn, reaffirmed the principles set forth in Heller and held that the assault weapons covered by Maryland's law fell outside the Second Amendment's protection because, like the M16, they are militaristic weapons that are ill-suited for self-defense. Now, here they're basically trying to persuade the court not to take the case. They don't want the Supreme Court to take the case. Why do you think that is? Well, I think it's because they know they're going to lose if the Supreme Court actually does take it. So it continues on here to say, the petition identifies no persuasive reason why this court should grant the review. Petitioners point to no split amongst the circuits regarding the constitutionality of, quote-unquote, assault weapons prohibitions. Moreover, they cannot show either that the Fourth Circuit's decision conflicts with this court's unambiguous statement in Heller regarding weapons that are more useful in military service, etc., or that the Fourth Circuit's historical analysis depart from the court's pronouncement in Bruin, and more recently in the United States v. Rahimi. Still, even if this court were otherwise inclined to revisit Heller's statement regarding militaristic weapons, or to consider Bruin's application to assault weapons bans, doing so in this case would be premature. Whether assault weapons are covered by the text of the Second Amendment following Bruin, and whether a ban on such weapons is supported by this nation's historical traditions, are questions that have only begun to percolate in the courts of appeals. And I say that that's actually not the case. This has been going on for quite some time now. Now, I could continue reading, but it's pretty much more the same thing. It's the state of Maryland basically telling the Supreme Court, please don't take this case. We don't want you to take this case. We don't want you to revisit Heller. We don't want you to look at this in light of Bruin. We know that you reversed the previous court's decision and sent it back down for us to take another look at it post-Bruin, but we don't want you to take a look at the work that we have done here. There's basically no way for them to fight against this. They know that, and so they're essentially, again, begging the Supreme Court not to even take this case. So that leads us to where we are today, with the petition being filed and the response finally being filed after all of the games, all of the waiting, all of the delays, all the different tactics that were used. We finally have a response from Maryland. So now the ball is in the Supreme Court's court. So it's up to the Supreme Court what to do with it next. Obviously, you know that Maryland is begging the Supreme Court not to take it, but we'll see. It's going to go to conference, and the Supreme Court will consider at that conference whether or not they're going to take it or send it back down or what exactly they're going to do with it. This case is going to go to conference. We'll get a date on that, and then the following Monday is when we usually find out what the Supreme Court does. They might wait another week, maybe send it to the next conference, or they could just tell us right away whether they're going to take the case or they're going to send it back down or, or whatever. But sometimes these things take a while. Like we saw with, previous decisions, it could take 6 different conferences before we finally get an answer. But at least now we are at the final stage. This is where the Supreme Court has to come to the table and finally put this issue to rest. Because if they don't, the issues that we're having right now at the appellate court level and the district court level are just going to continue to happen, and these governments are going to run rampant with these bans. There needs to be some clarity here from the Supreme Court, and I think just based on recent Supreme Court precedent, we know what that clarity is going to be. So I am hopeful that they'll take up this case. Hopefully when we actually get a conference date on this, we'll find out fast afterwards, but I'll let you guys know when that conference date actually is. I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe, and you guys have a great day.